Hello everyone. As you know, I'm back to do another dictation. This will be at 1:40. I thought I made one last night from the same take that we've been working on, Duress, but I guess I didn't, so here it is. Ready? Let's begin. Plaintiff brings this action seeking to recover the sum of $5,000 and interest upon written instrument in question was no consideration for the execution of the instrument in question. Second, defendant alleges that the instrument in question was obtained from the defendant by duress, that plaintiff being armed with a revolver threatened to shoot and kill defendant if he did not sign the instrument to shoot and kill because of such threats, and in fear that plaintiff would carry out his threats, defendant was compelled to sign said instrument. The instrument sued upon in this action is a written promise to pay money. It is not a negotiable promissory note and does not carry with it the same presumptions as a negotiable instrument, such as a promise to pay. If it is found to have been given for a valuable consideration, is valid and enforceable in law unless some valid defense thereto is shown. The first defense set out by the defendant is that there was no consideration for this note or instrument. A valuable consideration may be any advantage or benefit to the other party. A promise by one person to pay money to another cannot be enforced unless such promise is given for some valuable consideration. It is for you to determine from the evidence in the case whether or not any valuable consideration was given to this defendant for this instrument. If you find from the evidence in the case whether or not any valuable consideration was given to this defendant for the instrument, if you find from the evidence that the instrument was not given for any valuable consideration, then plaintiff cannot recover and your verdict should be in defendant's favor. The second defense set out is that this instrument was obtained under duress. Duress may be defined as the coercion of one person by another by means of bodily restraint, threats, or serious injury, pressure, or constraint to such extent as to go against his will and destroy his power of refusing to comply with the unlawful demands of another. Duress is a species of fraud in which compulsion in some form is the means employed. A note of contract obtained by duress cannot be enforced in an action of this kind. The burden of proof in this case rests upon the defendant on each of these two defenses to prove the same by a preponderance of the evidence, that is, by a greater weight of the evidence. Now, if you find from the evidence under the rules given you that this instrument was given for a valuable consideration and that it was not obtained by duress, then you should find a verdict in favor of the plaintiff for the amount claimed plus interest. On the other hand, if you find from the evidence under the rules given you that there was no consideration given for this instrument, or if you find from the evidence that this instrument was obtained from the defendant by duress, then in either such case, you should find a verdict in defendant's favor of no cause of action. That was at 1:40. Hope you got it all down. And if you didn't, practice, practice, practice. Have a great day.